is such a pleasure for me to welcome Judge Leicester Adams. I have been acting in our division for the third time during the first term, and on every occasion when I acted, I had the freedom to consult with Judge Adams whenever I found myself dealing with a sticky situation. Now, as the South African Bar Association, I'm not sure for those of you who are the first-time attendees to these sessions, we're hosting these sessions as regularly as we can on a Thursday. For the first year of our existence, we did it every Thursday, and of late, we're doing it every second Thursday, given the demands on time so far as the presenter's time is concerned. And this we do at no charge to participants, and in order to make a contribution towards uplifting the capacity insofar as competence of legal practitioners is concerned. Now, I am going to ask Judge Adams to switch his camera on, and so that you can all see him and obviously hear him. And I hand over to you, Judge Adams.
Yes, good afternoon, Mr.
Judge, you're still muted.
Okay, good afternoon, everybody. Good afternoon, Mr. Ford. Can everybody now hear me? Can you hear me and see me, Mr. Ford?
I can see you clearly, Judge.
Yes. Okay, then we're ready to start. Thank you so much for inviting me to discuss this important issue with your members. I think the idea came from the presentation I did to the judges from our division on this particular topic. So bear in mind that when I make the presentation and when we discuss the particular topic, it's from the point of view of the judiciary and from the judges of our division. But some of the issues mentioned is obviously of great importance to the members of the bar. I was asked to speak to you on the issue of the quantum of damages in unlawful arrest and detention matters, and the reason why I thought it necessary to address my colleagues on this particular topic is simply because of late there's been a tendency to award amounts way in excess of what the particular matters deserved. And for that reason, I thought it prudent at the time to speak to members of the judiciary on this particular topic. The SCA most certainly has noticed this tendency that from time to time there are this tendency to award amounts which are not deserving of the circumstances in a particular matter. So let me start off by quoting from a judgment that goes back 100 years. The matter is Halley versus Cox, 1923, a decision of the then appellate division in which Innes CJ had the following to say, and this is obviously from the point of view of a judicial officer. And what the Chief Justice said was the following. He warned that, quote, we cannot allow our sympathy for the claimants in this very distressing case to influence our judgment, end quote. The simple point that he was trying to make is that sometimes us being human beings would feel a lot more sympathy for a claimant in a particular matter and then have the tendency to award amounts in excess of what the matter deserves. So he just warned us to guard against that. Similarly, some 65 years ago, Holmes J. in the matter of Pitt versus Economic Insurance Company Limited, commented as follows, and this is one of my favorite quotes. If you've appeared before me, or if when I was still in practice you were against me, this is the quote that I would often cite in relation to quantum of damages. And this is what Holmes J had to say, quote, the court must take care to see that its award is fair to both sides. It must give just compensation to the plaintiff, but it must not pour out largesse from the horn of plenty at the defendant's expense, end quote. So in awarding general damages generally, but especially in cases of unlawful arrest and detention, judicial officers would be well advised to heed these caveats. One's award should always be fair, not just to the claimant, but also to the defendant, whilst at the same time not losing sight of the fact that in these type of cases, there would have been a serious infringement of the arrestee's constitutional rights to equal protection and benefit of the law, human dignity, freedom and security of the person, and freedom of movement. The important point is that one should strike a balance between awarding an amount which is fair to the claimant, but at the same time, not doing so at the expense of the defendant. And how does one achieve that balance? And the way to do that is simply to have regard to any and all of the relevant circumstances in each matter. Bear in mind that in relation to general damages, it is settled law that the trial judge has a large discretion to award what he, in the circumstances, considers to be a fair and adequate compensation to the injured party for the sequelae of his injuries. An appeal court will not interfere unless there is a substantial variation, or as it is sometimes called, a, quote, striking disparity between what the trial court awarded and what the appeal court considered ought to have been awarded. And we'll see later on when we discuss the specific cases that from time to time the SCA in its wisdom had obviously thought that there was a striking disparity between what the High Court had awarded against versus what they think ought to have been awarded. And in those circumstances, more often than not, the SCA does not shy away from substituting their award with that of what has been awarded. So then the question is, what are the factors that should be taken into consideration when awarding damages? I don't think I can do better than quoting from the Minister of Safety and Security versus Chulu, 2009 SCA judgment, in which the SCA had the following to say relative to the issues to be taken into consideration when quantifying a claim for unlawful arrest and detention. And this is what the SCA had to say, quote, in the assessment of damages for unlawful arrest and detention, it is important to bear in mind that the primary purpose is not to enrich the aggrieved party, but to offer him or her some much needed solatium for his or her injured feelings. It is therefore crucial that serious attempts be made to ensure that the damages awarded are commensurate with the injury inflicted. However, our courts should be astute to ensure that the awards they make for such infractions reflect the importance of the right to personal liberty and the seriousness with which any arbitrary deprivation of personal liberty is viewed in our law. I readily concede that it is impossible to determine an award of damages for this kind of inuria with any kind of mathematical accuracy, although it is always helpful to have regard to awards made in previous cases to serve as a guide. Such an approach, if slavishly followed, can prove to be treacherous. The correct approach to have regard to all the correct approach is to have regard to all the facts of the particular case and to determine the quantum of damages on such facts. Similarly, apropos having regard to previous awards, it was held again by the SCA in the Minister of Safety and Security versus Seymour, that the assessment of awards of general damages with reference to awards made in previous cases is fraught with difficulty. The facts of a particular case need to be looked at as a whole, and few cases are directly comparable. They are a useful guide to what other courts have considered to be appropriate, but they have no higher value than that. So in making your submissions to a court relative to the quantum to be awarded in respect of unlawful arrest and detention, bear in mind that previous awards should be used only as a guide, and each matter would be decided on its own peculiar facts. The process of comparison should not take the form of a meticulous examination of awards made in other cases in order to fix the amount of compensation, nor should the process be allowed so to dominate the inquiry as to become a fetter upon the court's general discretion in such matters. Comparable cases, when available, should rather be used to afford some guidance in a general way towards assisting the court in arriving at an award which is not substantially out of general accord with previous awards in broadly similar cases, regard being had to all the factors which are considered to be relevant in the assessment of general damages. At the same time, it may be permissible in an appropriate case to test any assessment arrived at upon this basis by reference to the general pattern of previous awards in cases where the injuries and their sequelae may have been either more serious or less than those in the case under consideration. And the authority for those propositions is the case of Protea Assurance Company Limited versus Lamb, which goes back to 1971. The point made is simply that in quantifying damages in these type of matters, one should have a feel for what you believe to be just and fair. Once you have that particular amount in mind, go to the previous awards and see how that particular award that you have in mind compares with those previous awards. But again, one is not to follow slavishly the amounts awarded previously. The next question that I need to then consider is, what are the factors that one should take into account when quantifying damages in unlawful arrest and detention matters? And in that regard, I've borrowed from the authors of a publication called Law of Damages by Visser and Potgieter, who did a very helpful exercise in that they went through tens, possibly hundreds of cases to establish what the courts over the years have regarded as factors which are relevant to the assessment of damages in these type of matters. And this is what the authors have to say as far as this particular issue is concerned. In deprivation of liberty, the amount of satisfaction is in the discretion of the court and calculated ex aequo et bono. Factors which can play a role are the following. But before I move on, let me just tell everybody that that Latin phrase, foreign as it may be, simply means out of a sense of what is right and what is good. So it's a very fancy way of saying what is just and fair, all things considered. So these are the factors which they have been able to extract from all of those many cases that they have had regard to. The circumstances under which the deprivation of liberty took place, the presence or absence of improper motive or malice on the part of the defendant, the harsh conduct of the defendant, and we often find this, that in addition to being unlawfully arrested, a claimant would then be assaulted by the police in the presence of other members of the public, so much so that his dignity is very severely affected by the arrest. Then the next consideration is the duration and nature, for example, solitary confinement or humiliating nature of the deprivation of liberty. The status, standing, age, health, and disability of the plaintiff, the extent of the publicity given to the deprivation of liberty, the presence or absence of an apology or satisfactory explanation of the events by the defendant, and then importantly, awards in previous comparable cases, the fact that in addition to physical freedom, other personality interests such as honor and good name, as well as constitutionally protected fundamental rights have been infringed, the high value of the right to physical liberty, the effects of inflation, the fact that the plaintiff contributed to his or her misfortune. And as far as that particular consideration is concerned, one often have a situation where the claimant or the plaintiff had committed the offense, albeit a trivial offense. An example that comes to mind is smoking or possession of dacha at the time when it was still a crime to possess dacha, and then the police arrest them and keep them overnight. The point is that in those circumstances, the quantum would probably be reduced by the fact that the plaintiff in those circumstances would have been the author of his or her own misfortune. Then the next consideration is the effect an award may have on the public purse. And lastly, according to some, the view that the ectio injuriarum also has a punitive function. So those are all of the factors that one should take into account when awarding general damages in cases of unlawful arrest and detention. So how does this translate into rands and cents? And I have had a look at a few recent cases, because that is the type of cases that one need to look at when you deal with these matters. Is the recent one. There's no point in quoting to a judge hearing your matter, a 1936 matter, in which somebody arrested and was paid what would have been in pennies and pounds at the time. So this is what I found. And these are the important cases that come mainly from the SCA. And you would have, in your practice, have seen that they are quoted and cited more often than not when these matters come before court. The very first matter is the oft-cited matter of Seymour, which I've referred to above. A 63-year-old man had been unlawfully arrested and imprisoned by the state for a period of 5 years, for a period of 5 days. He had free access to his family and a doctor throughout his detention. He had suffered no degradation beyond that which is inherent in being arrested and detained. And after 24 hours, he had spent the remainder of this detention in a hospital bed. In 2006, the SCA awarded him 90,000 Rand. In the process, what they did as the SCA, they had reduced the award from 500,000 Rand, which had been awarded by the Johannesburg High Court at the time. So this is a good example of a large disparity between what the appeal court regarded as an appropriate award versus what had been awarded by the trial court. And the second case is the Chulu matter, which I also referred to earlier. Interesting case in that a 48-year-old magistrate who had served for 12 years was arrested while walking in the early hours of the morning. The police alleged that he was drunk and that he matched the description of a person who had fled the scene of a motor accident in the vicinity. He was first arrested for being drunk in public and then later at the charge office, and after having been identified by the witness, arrested a second time for drunken driving. The arrestee admitted to consuming 6 beers. His blood alcohol level was tested to have been substantially more than the legal driving limit, and he was moderately under the influence when examined shortly after the arrest. He was detained for a few hours and released the next morning. This, for me, is a classic case of being the author of one's own misfortune. And this was probably one of the main considerations by the Supreme Court of Appeal, which awarded 15,000 Rand to the magistrate, reducing the award by the High Court. It was the Western Cape High Court from 280,000 Rand. So that was in 2009. Again, the SCA thought that there was a huge disparity between their 15,000 Rand and the 280,000 awarded by the High Court. Even more recently is a matter of Diljan against the Minister of Police. It's a 2022 judgment by the SCA. In that matter, a lady suspected of having committed the offense of malicious damage to property was arrested on Friday afternoon and detained until Monday, when she was released from custody. She was kept in appalling circumstances. The condition of the police cells in which she was detained was filthy with no hot water. I'm sure this is a familiar scene and a familiar story to most of us. The blankets were dirty and smelly. The toilet was blocked. She was not provided with toilet paper, and she was not allowed visitors. She could not eat the bread and peanut butter. It was the only food provided to her. She was deprived of visitation rights by her family, and that resulted in her not receiving medication for her heart condition. She was deprived of her liberty for 3 days, and the award the amount of the award made by the SCA was 120,000 rand. There was no award made by the High Court because the High Court had dismissed the claim on the basis that the arrest and detention was not unlawful and wrongful. So 120,000 rand for a weekend in jail after the young lady had committed the crime of malicious damage to the property. This, in fact, was a fight between two neighbors. Importantly, in Diljan, the SCA criticized the excessive award in a High Court matter in which, to which it had been referred, namely Kedama versus the Minister of Police, which is a judgment of the KwaZulu-Natal High Court in Durban, in which that court had awarded to the plaintiff, who was arrested and detained for a period of 9 days, a whopping 1 million rand. In fact, if the presiding judge in that matter had his or her way, the award would have been for 1.8 million rand. The only reason why the judge awarded 1 million rand was because that was the amount that had been claimed by the plaintiff in his particulars of claim. All the same, this is what the SCA had to say. And like I say, this is a 2022 judgment of the SCA, and it just needed to remind everybody, including the High Court, that sometimes one needs to ensure that one does not pour largesse from the horn of plenty at the expense of the defendant, which more often than not is an arm of the state. That's the quote going back to 1953. All the same, this is what the SCA had to say. Quote, "A word has to be said about the progressively exorbitant amounts that are claimed by litigants lately in comparable cases and sometimes awarded lavishly by our courts." And this is important from the counsel's point of view. Legal practitioners should exercise caution not to lend credence to the incredible practice of claiming unsubstantiated and excessive amounts in the particulars of claim. Amounts in monetary claims in the particulars of claim should not be, quote, thumbsucked, end quote, without due regard to the facts and circumstances of a particular case. Practitioners ought to know the reasonable measure of previous awards, which serve as a barometer in quantifying their clients' claims, even at the stage of the issue of summons. They are aware, or ought to be, of what can reasonably be claimed based on the principles enunciated above. So, as I indicated, the point about this matter is that one should not pour largesse from the horn of plenty at the expense of the defendant, and your award should be fair to both parties. But more importantly, from the point of view of today's presentation, there is also a request that when making submissions on behalf of your client, that one should be fair in making those submissions and be of assistance to the court in ensuring that a fair award or quantum is made to any particular plaintiff. I just also wanted to refer to a matter of Mati versus the Minister of Police, which was a judgment of the Johannesburg High Court, a judgment by my learned sister, Opperman J., in which a 31-year-old mother of 2 children arrested on suspicion of prostitution and detained for 37 hours before release at court after charge of prostitution dismissed, in which she awarded an amount of 120,000 rand. That particular matter, the award was made after the Johannesburg High Court had considered awards in comparable matters up to that point. Very useful judgment in these type of matters. Mathy versus the Minister of Police, 2017, Volume 2, SACR 211, a judgment of the Gauteng Division of the High Court. And then also Minister of Police and another versus Erasmus, which was a 2022 judgment of the SCA, in which the plaintiff was suspected of having committed the crime of housebreaking with intent to steal and theft. He was arrested and detained in unpleasant condition for approximately 20 hours, and the High Court awarded 50,000 rand. The award was reduced to 25,000 rand by the SCA. The reason why I specifically mention this particular matter is for 2 reasons. Firstly, I think the SCA wanted to make the point that the fact that the difference between what they had in mind and what the High Court awarded was a paltry 25,000 rand doesn't really make such a huge difference. But they wanted to make the point that in this particular matter, because the plaintiff was called the author of his own misfortune, he was entitled to as little as possible. And this is why they literally gave him almost next to nothing, the 25,000 rand. Yeah, that's the first reason. And the second reason was that in having regard to whether or not they consider that there's a large disparity between their award and what has been awarded, it's not really about the rands and cents. It's really about how much ultimately, in the bigger scheme of things, ought to have been awarded by the previous court. And then lastly, Minister of Police versus Mzingeli and others. Again, a decision of the SCA makes for interesting reading, not only because the High Court in Mthatha awarded the 2 plaintiffs 4 million rand and 3 million rand respectively for being unlawfully incarcerated for lengthy periods of time, but also because the SCA found it wholly unacceptable to quantify damages on the basis of so-called stated cases. What the SCA said in that matter was, in order to do justice to the quantum of a plaintiff's claim in unlawful arrest and detention matters, ideally the trial court should hear evidence on those particular aspects, which sometimes requires a subjective reporting of what the plaintiff had to endure during that arrest and detention. Yeah, so that is what I wanted to say in conclusion. Let me just say that if the awards by the SCA are anything to go by, erring on the side of caution and conservatism seems to be advisable. And remember, when making submissions to a court, you should always bear in mind that largesse should not be sword from the horn of plenty at the expense of the defendants. Yeah, those are the issues that I wanted to raise, Mr. Ford. I don't know if there's any other questions that people would like to ask.
Thank you. Thank you so much, Judge, for that very informative presentation.
Yes, it's my
We will
pleasure.
now open the floor for questions. And whilst you're thinking of a question, you may either raise your question in the chat box or you may raise your hand. And whilst that's being done, Judge, perhaps let me ask a question. I remember during the reign of our previous DJP, Mojapelo, during roll call, if a matter concerned an unlawful arrest for a day or two, that
Yes.
it's instantly decided that must go to the magistrate's court.
Yes. Yeah.
What is the position of late insofar as assessing the extent of a unlawful arrest claim by merely linking it to the number of days that somebody has been detained? That is the first question. The second question I have is, are there any considerations that the court would apply insofar as the practitioners for bringing to court claims and exaggerate the extent of the damages? For instance, where a person was detained and arrested for a very short period of time and then file a claim for damages in 1 million, possibly 2 million, in order to bring it within the jurisdiction of the High Court.
Yes, yeah. Thanks for that question, Mr. Ford. Firstly, as far as judging or prejudging a matter on the basis that it belongs in another court is concerned, I think the point that I always make to litigants is that you know, the jurisdiction of the magistrate's court is 500,000 rand. Please explain to me how, on any basis, your claim where he was arrested for 1 to 2 days is going to get anywhere near the jurisdiction of the magistrate's court, and more often than not, the representatives are not in a position to confirm that, because from the authorities that I've just referred to, you can see that if you get 200,000 rand for a weekend, you on the upper edges of the awards. So yeah, you know, the point is that you unless you can convince the court otherwise that there are special circumstances, I think the reality of the matter is that the matter probably belongs in another court. But having said that, we all know that there was the recent judgment by the Constitutional Court that said that the High Court cannot and should not insist that the matter be heard in the other court. Litigants are at liberty to have their matters heard in the High Court, although they run obviously the risk of having of not receiving a cost award on the appropriate High Court scale. Yeah, that was the first. What was the second question again? Sorry.
The second question had to do with the repercussions for legal practitioners exaggerating a claim.
Yeah. Look, I suppose you again run the risk of getting a bonus proprius cost order awarded against you, except that I know for a fact that judges are reluctant and loath to do that. Some of you may recall that a few years ago there was an award by this court against certain legal representatives. It was taken to the SCA and the legal representatives had it overturned for the simple reason that the trial court had not heard their side of the story before making the adverse punitive de bonus proprius cost order against them. But the possibility is there that that one can get a de bonus proprius against you. Although, like I say, judges are reluctant to do that unless there's really been malice on the part of the representative and just gross negligence in pursuing a claim in circumstances where it's clearly exaggerated.
Judge, I haven't seen any hands. There was few comments, but I see they've been appropriately dealt with in the chat box. Perhaps I can ask another question.
Yes.
Now, in your personal injury road accident fund matters, you've got the benefit of Koch's handbook on quantum of damages. Has there
Yes.
ever been an initiative towards working on a quantum of damages handbook for Minister of Police matters, where one could effectively apply sort of a sliding scale to say, if you've been arrested for 1 day, assaulted, your dignity subjected to impairment, then you would qualify for X. And if the circumstances are incrementally worse, so too would be your claim for damages.
Yeah, I'm sure you heard that same question arising when we had this presentation with the members of the judiciary. I think the judges and the courts generally are reluctant to give a going rate as such, for the simple reason that one would then be unnecessarily fettering the discretion that a court has in making these type of awards. But I know that the Quantum Yearbook, or whatever the other publication is, also from time to time would have a list of matters where they give an indication of what type of awards are made for what periods of time. So I suppose from that one can draw your own inferences as to how much the going rate is, provided you understand that the going rate is in fact a range between certain amounts and not an average amount. I, for example, recently awarded in one of my matters an amount of 200,000 Rand and 250,000 Rand for two ladies that were detained over the weekend from Friday until late evening the Monday, and then after that they still had to face the prosecution. I thought that was deserving of an award higher than the usual award, for the simple reason that they were treated very badly. They were on their way home and they were hauled off a bus traveling to the Eastern Cape. They were on their way home and they had absolutely no idea what these alleged charges against them were about. They explained to the police, not once, twice, that they know nothing about this. They don't even know, they've never been to the place where the incident or the alleged crime had happened. The one set of police actually believed them and they accepted what they had said. And then a few hours later, they were again confronted by the complainant and the police. And they said, but we just explained to you, we don't know anything about this. So in those circumstances, I had awarded, like I say, 200,000 and 250. The 250 was because the other lady spent an additional night in the police cells. So yeah, if you have regard to the awards, you look at for a weekend anything between 50 and 150,000 Rand as an average award. Anything higher than that, it needs to be justified, lest the SCA interferes.
Any other question from any of the participants? Advocate Romeo Tambaleni.
Thank you, Advocate Ford. I don't have any questions to Judge Adams. Thanks.
I see there's a question on the chat box, Mr. Ford.
Judge, let me just open it for you. Yeah. Judge Howard, you can see the question and just respond to it?
Yes, yeah, okay, it says, one of the purposes, it's from Arno Smith, one of the purposes of claiming from the Minister of Police is to deter unlawful arrests. Given the large number of unlawful arrest cases still coming before the court, is it not perhaps prudent and in public interest to inflate the quantum in order to serve as a real deterrent? It seems like the Minister of Police is not being deterred by the current amounts granted against it. Yeah, I suppose, Council, that's one way of looking at it, except it brings us back to what I said right at the beginning. You know, this is the public purse that we're talking about. One way of maybe looking at deterring these unlawful arrests would be to hold people personally liable. And maybe there will come a time when the courts start doing that. But awarding higher amounts against the minister, I don't know if that would serve the purpose of deterring these unlawful arrests. It is so that the numbers are just increasing quite dramatically, and on a weekly basis we have anything between 10 and 20 matters on the roll in this division alone. So yeah, we need to find a way to address those issues, but awarding higher amounts, I'm not so sure that that would serve the purpose.
Yeah, Advocate Ford, let me just follow up with a question from what Judge Adams is actually talking about. Judge Adams, I just want to find out from you. You were speaking about the middle amount that should be awarded in terms of spending a weekend, from 100 to about 150,000. Is there a specific amount? Ford was asking that a day in prison, maybe it's 50,000, for instance, or 25,000 from the decisions that came from the Supreme Court of Appeal, so that at least one is able to know more or less as to, if you spend a month, how much damages can you actually put in your summons, at least. Thank you.
Yeah. No, but this is exactly, Council, what the authorities warn us against. They say don't. You can't say that the going rate for a day in prison amounts to 20,000, and then calculate over 365 days times 20,000 and you get to that amount. It definitely doesn't work that way. And I think there's been attempts to make those submissions. In fact, the matter that I mentioned to you just now, Kadema, that was the submissions made, and you see what the SCA thought about that approach. They just completely disregarded it, and they say that's not the way to do it. You must award an amount that you feel is just and fair, and all things considered. And if one and one of the considerations that you should have regard to is the period, the period during which the detention had endured. But ultimately, I don't think it's right to say that, oh, you've been in prison for 6 months and therefore you must get 18 million rand, whatever the case may be. It must still be, all things considered, fair and just. Yeah.
Okay, thank you so much, Judge. Thank you.
Thank you.
Thank you so much, Advocate Ntambeleni. Are there any other questions, comments, inputs? Well, Judge, it appears there aren't any further comments, inputs, or questions, which leaves me only to thank you for your time and for your presentation. And I have your presentation, and those of you who attended the presentation this afternoon would like to have a copy of the presentation made by the learned Judge Adams. You're free to contact me. My details are all over social media and on the website, and I will gladly email you a copy of the presentation. Judge, it was always a pleasure to listen to you on a Thursday. I think what the practitioners don't know is that every Thursday you host a development session for the judges, and which is really helpful and incredibly insightful. And
Yeah.
that is the sort of the tradition that we're passing on at the South African Bar Association as well. So
Yeah.
from us, thank you so much for your time. And we will be inviting you back onto the platform in the very near future.
Yes, no, thank you very much, Mr. Ford, and to all the other members of the bar. Thank you. It was a real pleasure being here, and it's an honor to have done the presentation. Thank you so much.
Right, to our participants, go well. Thank you for attending, and we'll see you again next week.
Yes. Thanks, everybody. Bye.